Today starring Bill Schlechte.
And I wasn't even supposed to be here today. I was
You were supposed to be out of
I
town.
was supposed to be in the air, flying to South Dakota today. Yeah, for pheasant hunting. But my one son canceled on me 2 weeks ago. My other son canceled on me recently, so I decided I really didn't want to go out there by myself. Because yeah, I mean, the half or more of the fun is sharing it with somebody
Sure.
else. So I'm going to try and reorganize the trip for sometime in early or mid-November. Hopefully that works out. So, and hopefully the pheasant season
Well,
out there
welcome.
is decent. Yeah. Hey, thanks a lot. So what I should also say is now I'm going to be here for the Michigan opener, which is it's still on the 20th. I haven't hunted pheasants in Michigan in a number of years. So here's the shout out. If somebody knows,
October 20th?
Yeah, I think it's October 20th. That's when it used to be, and I assume that they haven't changed it. So if there's somebody out there that knows of a nice piece of ground with the possibility of pheasants there. I mean, one reason we started going to South Dakota years ago was because pheasant population in Michigan had diminished so dramatically that it wasn't worth going around here. So, but if somebody knows of somebody, usually down toward Hillsdale, that area, if they know of a piece of ground to hunt and that's available, why don't they give me a call at 734-476-9432. I'm dead serious about this, okay? I mean, if I'm gonna be around, I might as well go.
A
pheasant hunting and
shameful
help.
solicitation.
What the hell?
For
You know?
Okay.
I mean, think about all the listeners out there that have gotten free legal advice over these years
Wow.
during this program, and
That's
so
true.
what the hell? A little quid pro quo. Find me some ground to hunt on October 20, please. All right. So
With pheasants.
yeah, with pheasants, Well, hopefully with the prospect of pheasants. Like I say, that's one of the reasons that we stopped hunting pheasants in Michigan. So, and in South Dakota, I don't know what the prospects are on South Dakota this year. I started going in 1980. And only 2 years out of 36 years has it been less than absolutely spectacular hunting. Anyway, so how are you? Good.
I'm good.
All right. What do you want to talk about today? You got anything in mind? Any particular? I don't want
Do
to
you
talk
have
about the
any
election.
houses?
I don't have any houses to sell. I'm a lawyer. What the hell? I'm a guy that comes in after the fact to try and clean up the messes that people create. Okay? Thank God they do that. No, what I was going to talk about when Laura arrives is disclosure statements, confusion about disclosure statements, confusion about disclosure of the condition of the property, those sorts of things.
What is a disclosure statement?
Well, there's a statute in Michigan that was adopted in, I want to say 1980, no, not 1988, 1998. The requirement that a seller of real estate give a written disclosure statement, it's a statutory form, to a prospective purchaser. This is in residential sales for family or fewer residential properties. And it includes vacant land that's intended to be used for construction of a personal residence on it, or for family or fewer residents. The interesting thing about the statute is it requires that it be given, but there is no penalty if the seller fails to give it, other than that the purchaser can back out at any time up until the deal actually closes. So you do still see occasionally, although it's occasionally, probably rarely, where a seller refuses to give a statutory seller's disclosure statement. And I always advise purchasers, if a seller refuses to give it, I'd walk from that deal in a heartbeat, because what they're essentially telling you is they're not going to give a disclosure statement because there's something dramatically wrong with the property. So I would always insist upon the disclosure statement. That's why you asked me what we should talk about today, and that was one of the issues, because I'm encountering in both residential and non-residential cases defects that are discovered following the closing, not disclosed. Big difference between commercial deals and residential deals, because there's no requirement to give a disclosure statement in a non-residential deal.
What about if the seller,
Wait, let me put your.
what about
I
if
didn't
the,
see you sneak in here, Joe. Let me put your mic on.
I'm not that little. What about if the seller took the property back from a land contract, gets along with the people that they took the property back from, and,
This is a deal we just did, by the way.
right,
Yeah.
and, I mean, who should fill that seller's disclosure statement out, or how should it be filled?
There is
Because
none.
there's nothing to,
No, it's not, there is no sale There's no requirement.
No, I understand that, it's gonna go on the market.
Oh, you're talking about now the seller who took it back from the purchaser?
Correct.
Is now gonna give a seller's disclosure statement?
Correct.
Yes? What do you wanna know?
But he hasn't lived in it for 5 years.
Well, he simply says that. I haven't occupied the property for the last 5
But
years.
can because the previous owners, who bought it on a land contract are great people and, you know, they get along, the previous owners and the,
But I don't understand what difference that might make.
well, I'm just wondering, can they fill in the seller's disclosure or should it just be, is this current, so,
I wouldn't have the vendees who gave the property back, purchasers gave the property back on land contract, they're out of the deal. There's nothing that I would do with them.
so would there be a liability on the current owner who got it back if the previous owners filled in the or in the seller's disclosure and they made a mistake? So would are you following me?
I'm not,
So there's a property
yeah.
and the current owners bought it on a land contract and there's some problems, so they're giving the property back to the vendor.
You just misspoke, the current owner. Here's the way it works.
Well, they haven't,
The owner of the property
Straighten it out.
sold it on land contract 5 years ago.
right,
The purchaser on the land contract no longer, they defaulted, they're not able to make the payment, whatever it is, so they're giving the property back to the original owner.
Right.
Okay, so far, so good. So I got the same guy who owned it 5 years ago, but who hasn't occupied it for 5 years. Now, what do you want to know?
if the purchasers of the land contract fill out
The people who are gone,
they're not, yes, they're still around, but they're not in the
they're not
house.
in the contract.
If the current owner asks them to fill in the seller's disclosure because he hasn't lived in it in 5 years, is there a problem for the current seller?
Yes.
If there's a mistake made on the seller's
Yeah,
disclosure?
why would I do that as a seller? I mean, I don't want to, I'm a little bit incredulous that a seller would want to do that. The seller is giving a seller's disclosure statement. The seller's disclosure statement, by statute and by the language in the form, says that it's based upon the seller's knowledge and information. So the seller doesn't want to go out to the vendee, who's no longer in the land contract, and say, hey, look, tell me what's wrong with the property, tell me what you know about the property. Because then when the vendee fills it out, who's going to sign it? Is the vendee going to sign it or the owner?
I don't know.
Well, no, you'd have the owner sign it, and
Could the owner say this was filled in by the previous
I think you need a lawyer.
purchaser? Yeah, I know,
on
I'm
this one.
trying to get an answer from a lawyer. but-
the answer is easy. The answer is you don't ask the vendee who's now gone, who gave the property back, they're out of the picture, don't even ask them. Seller says on the seller's disclosure statement, I haven't resided in the property for 5 years, here's what I know about the property, it's to the best of my knowledge and information. And that's all the statement is, that's all the seller's disclosure statement is. If it turns out that there is something else wrong with the property, it's discovered after the closing, but the seller didn't know about it, had no reason to know about it, then the seller's not responsible. That help? And that's actually a clear, concise, comprehensive answer from a lawyer. I know it's difficult to believe. You're looking at me with a great deal of incredulity.
Okie dokie.
So, all right, but I was talking more generally about the seller's disclosure statement.
Right, well, I had a specific question, so
Okay.
I thought it was an interesting one.
As a seller, you don't want to go out looking for problems. This is like the years ago, I want to say when the
But
sellers...
you, say there's a hole in the roof
Yeah,
and you're giving the property back,
okay.
that have,
Has a hole in the roof.
maybe you don't know it.
Well,
Well,
wait.
Come on.
Wait, I gotta know there's a hole in my roof.
No, you don't.
You
Not necessarily, it could be a small
You
hole.
should, but maybe you don't.
Well, okay, here's the way the law works in Michigan. Okay, that's
So you're giving it back,
Okay,
land contract.
yeah, all right. I'm giving it back to the original owner / seller, right? Okay, now
But
that...
if you know there's a hole in the roof,
Yeah, but I'm giving it...
you have to disclose, right?
No. In this case, you're talking apples and oranges here, guys. Laura's talking about once the vendee is out of the contract, is given the property back to the original seller.
Right.
She wants to know what that seller has to disclose to somebody else.
Oh, okay.
That's what she's talking
just
about.
The normal
Yeah, it's a normal thing.
Disclosure.
If I know what it is, I disclose it. If I don't know, I can't disclose what I don't know.
Well, take it back a notch, what has to be disclosed to the original owner?
Nothing.
Not a thing.
Not a thing. Not a thing. Matter of fact,
The place could be trashed.
affirmative,
Okay,
and often is.
now I'm clear.
Yeah, now here's the other issue. I see this on this particular deal, and this is common, happens all the time, and it happened all the time in the Great Recession beginning in 2008, where sellers were taking properties back. When you sell on a land contract, you're giving up an interest in title. You're not giving up legal title, but you're giving up beneficial title. Let's suppose that contract goes on 5 years. The vendee now defaults, the purchaser defaults, and wants to give the property back. The vendor, and I see this happen more frequently than not, the vendor says, okay, they go to a lawyer, the lawyer draws up a quitclaim deed and a termination of land contract. The vendee signs a quitclaim deed, gives it back to the seller. You can't do it like that. What you have to do is, as a seller and as a seller's lawyer, you have to have a title search done to determine whether during the 5 years that land contract was in effect, to discover whether or not the vendee did anything to the title that would be prior to the seller's interest. When the seller takes the quitclaim deed back, anything that happened in that 5 years, that seller's subject to. And so you have to have a title search done. Is there a construction lien? Is there a land contract mortgage that was given? Was there some other lien that was placed on the property? And Michigan law says that as a vendor on a land contract, or as a mortgagee on a mortgage, if you simply take a deed back, you take it subject to whatever happened during the intervening time, in this case when the land contract was written, and 5 years later when it's given back. What you have to do as a vendor, and as a vendor's lawyer, is if the vendee wants to give it back, and there's an intervening lien, you gotta go through the entire foreclosure process in order to eliminate that intervening lien. And that's one of the problems that happened during the recession, is sellers didn't understand that, and their lawyers didn't understand that either. So that created a problem for them.
Well, it seems like that would have to happen.
Having a title search, or?
Yeah.
Yeah, well, but people don't think about it.
Lawyers don't know that? I mean,
Most lawyers don't understand that you can't simply take a property back on a quitclaim deed, that if there is an intervening lien, you must go through the foreclosure process to add that other party as a party to the litigation in order to eliminate that intervening lien, or that interest. Yeah.
but if the property is, let's just
If
say
it's free and clear, yeah.
it's
this one-
trashed,
Oh, if it's trashed, and then the.
too bad?
Well, the vendor needs to go in there, the seller needs to go in there, and if it's trashed, say, no, I'm not simply gonna take the property back. If you want me to take it back, you're gonna pay me an additional amount of money so I can rehab the property. The vendee's never gonna do that. So what you then do is you actually start an action against the vendee, foreclose, and get a deficiency judgment in order to get damages against the vendee
So
for
there
them
would be a
trashing the property.
That would be a lawsuit.
That would be a lawsuit, yeah, absolutely, absolutely.
And who doesn't like lawsuits, right?
Do we see that with the businesses that are bought in a land
With
contract?
business?
Yeah.
With a business? Oh,
Small business,
absolutely.
land
Oh,
contract?
God, yeah. Yeah, constantly, where somebody buys the business and the real estate.
And there's a lawsuit in the middle of this?
Yeah, what happens is the person who takes over the business, for whatever reason, the business doesn't succeed, and the seller of that business that sold the land on land contract and the business on a promissory note and a security interest, they end up taking it back, and it's usually the business now is severely diminished from what the seller had when the seller sold it 2, 3, 5 years ago, whatever it is, because the purchaser ran it into the ground. All of a sudden, that business is valueless or diminished in value.
Yeah.
The problem in almost every case is that the purchaser bought it when they bought it on time from the seller, because they didn't have the money to be able to pay cash for the business, couldn't finance it. Guess how collectible they are once that business goes down the toilet and they have to give it back, or they get foreclosed on by the seller.
Yeah, that's gonna be an issue.
Yeah, yeah.
But does that those end up in court?
They can, but a lot of them, what happens is, and I tell sellers this at the outset, you know, and I've been in practice 44 years, and this dates back 40-some years that this has been happening constantly, where sellers, they can't
Is that
sell
the caveman days?
the caveman days, Neolithic age, I think.
So
it is.
selling a business on a land contract,
Well, you
Would
don't sell a
would-
business on land contract. You sell land on land contract, or you sell
Right.
real property on land
Okay.
contract. You sell a business on a promissory note
Okay.
secured by a security interest in the assets, both tangible and intangible, okay? Yeah, there are tons of sellers who end up having to take the business back.
so you would advise against that
I would
if you were
advise doing it.
representing the seller.
Well, you can't, advising against it, what I advise them to do from a seller's perspective is to do as much or more due diligence regarding the buyer as the buyer does with respect
Well, they
to
can
the
destroy the
business
business.
itself. That's right.
Yeah, the buyer could be great, the business might be going
Yeah.
in the tube.
Yeah, I mean,
Or
that's a possibility. I
The
mean,
business might be great, and the buyer runs it into the tube.
Well, that's, yeah,
That's
that's one
more-
other
we've
scenario.
known people that
that's
has
more often the
happened.
case.
Right.
That's more often the case because
They don't know what they're doing.
because you have what's called a small family business or a closed corporation, small business, and what happens is that they now sell it, but because it is this family-run business, it's a small business, the purchaser is unable to go out. You know, they might not be able to get SBA financing, whatever the financing that they would like to get. So the seller ends up funding it through a land contract sale of the business, through the real estate and the building and the land, and then note and security interest on the business itself, and without doing due diligence on a seller's point of view, and the seller not keeping track of things on a regular basis. All of the agreements that we write for a seller would provide for constant and periodic reports as to what's going on in the business, the ability of the seller to get access to all of the financial information as the business is being operated by the buyer, a whole bunch of protections that are built in for the seller.
Very good.
I didn't really
You
get
cleared
into,
that up.
I really didn't get into seller's disclosure statements, but next week, how's that?
There's not enough minutes in 30.
Yeah, you're right. Yeah.
I,
So
I like
Oh.
land contracts.
I gotta make one other comment. I need to give a shout out to, what is it, Best in Show? This new pet shop
Best of
located,
Show.
Best of Show, new pet shop located at McCain and Robinson in that little strip mall. They just did a trimming of my dog, my hunting dog.
They did
And they did a
two
great job. They
trimmings
did a
and
a
really,
wash.
well, very personable people that are in
Yeah,
there too.
she's
I
a
mean,
nice girl.
And I like the person who was doing my dog before, but Laura happened to be out there and we.
No, we
had
were
a
out
good-
there eating
We're
at,
eating at
uh,
Chalangos, yeah.
Chalangos. That was very good food, by the way.
So anyway, so
The
I just
broken
want to
egg.
give it, I told the
Okay.
people at Best to Show that I would give them a shout out.
Okay, so I just wanted to talk real quick about, and we can go into this a little further, but the market has gone up in Blackman Township 11.35% since 2014, 21.57% in the city of Jackson, and 12.45% in Summit Township since 2014. So that's nice. Nice increase, right?
What do you mean the market's gone up?
The average sale price.
Okay.
So, we have a new listing coming up at 6306 Burning Tree. It will be on the market the end of this week, so if you're looking for a house in a nice house in a subdivision, it's over 1,700 square feet. I think it's 4 bedrooms, 2.5 baths, a fireplace, 2-car attached garage, and there's an extra 2-car detached garage, and it will have a brand new roof on it, 214.9. Nice sprawling ranch. And then we have open houses this weekend on Lori Drive, 6581 Lori Drive. That price has been reduced to $164.9. Western Schools, 4 bedrooms, 1.5 baths, over 2,000 square feet. And Mill Street, 387 South Mill Street, which is the village of Brooklyn, $249.9. It sits on the Raisin River. Beautiful, beautiful, especially right now with the leaves changing. 3 bedrooms, 3 baths, almost 3,000 square feet. Those 2 open houses on Lori Drive and Mill Street will be from 1 to 3 p.m. And then I've got a listing coming up on Seymour I think it's just a 2-bedroom, and then on First Street, so those will be nice for, you know,
Call this number,
780-3800.
website.
thinkingrealestate.com.
And now remember, 734-476-9432, Bill Schlechte, and I need hunting land down toward Hillsdale for pheasant hunting October 20.